You have questions, we have answers. This is Jane Muller.
And this is Ken Muller. Welcome to our show, all about real estate with Ken and Jane. Today, we're going to talk about the Use and Occupancy Agreement, better known as a U&O agreement. And basically, it's a lot of, it comes into play a lot in real estate. It's an important thing, and every buyer and seller should be aware of it. So to start with, I guess the basic question everybody's probably wondering is, what is a U&O agreement? So, Good question. All right, I'll do the speaking on this one. So, okay. A U&O agreement is a short-term agreement. It's used to allow the parties to the real estate transaction, the buyer and the seller, to close the deal, and then typically it's applied to the seller, where the seller, after the closing of title, the seller is allowed to stay in the home that they sold for a specified period of time, subject to a use and occupancy agreement, there's a lot of terms to it. It's not a lease, but it is a written agreement. It specifies the length of time, the daily amount, and the monthly amount that the seller must pay to the buyer for living there. And it's used there's particular reasons why a U&O agreement is used for the seller side. Number one, it's used if the seller's new home is not ready, so they might need additional time to remain in the house before they can move out. Another reason it's used is sometimes the seller may have kids in the school system, so they may, for personal reasons, want to stay in the house until the kids graduate from the school before they move. That there's other reasons too. Sometimes a third main reason is that there might be a financial reason. They may need the proceeds from the sale of their home to settle before they can move before they have the money to pay for their new house. And they might want to do it in an orderly transaction as opposed to doing piggyback closings, from their sale and buy, and then having to live on a trailer. They might want to just have time for the money to settle and then to move in at their leisure.
I think to add to that, Ken, it's not only the pleasure, because certainly, in my experience anyway, when the seller have back-to-back closing, first of all, where they going to buy, unless it's new construction, most cases, they would not take a back-to-back contingency, right? So that's really affect the seller's purchase ability, because sometimes if you have willing, ready buyer, why they want to add a contingency, right? So you would be on the back of the burner kind of thing, right? And secondly, I think it's, in addition to what you said, all those good reasons, maybe another reason to be considered is like sometimes typically my client, they are living in the house for a long time. They are really, they worry worms, like your mom used to say about you, right? The worry worms, they worried, how do I know we're going to close? How do I know? Okay, if the buyer's mortgage, how do I know the person doesn't lose his job? How do I know they're actually going to close, not going to change their mind on closing date? It's like almost useless to explain to them the contract, right? But it's always a chance it doesn't close, even if it's a cash transaction, right? So to make them feel comfortable, I often suggested, use the occupancy, because you closed. You're closed. You got your money.
Right, you have your money.
After that, you have 2 months or months to get out. So either rent or purchase or move to another home. So especially some my clients, they gonna go out of the state, and you want to make sure. So you got your money, and then you leave, whatever agreed time. So that's an additional reason,
right? Another reason could be that you need a U&O because the buyer needs to close because their rate lock is going to expire, but the seller's new home or wherever they're going to relocate to isn't ready yet. So they close the title, then the seller is allowed to stay for 10 days, 20 days, 30 days, whatever it's specified in the U&O, pay the daily rate, per diem rate, or pay the monthly rate. And then, but basically, the seller is a guest in the buyer's home because the seller no longer owns anything in the house. So everything in the U&O has to be spelled out as to who pays the utilities, what the per diem rate is going to be for the seller to live there. And normally, again, it's not legal advice, but normally the seller the rate is determined by what the buyer's carrying cost would be, and the seller is responsible for paying that, which would be the buyer's mortgage
interest,
mortgage interest, not the
interest.
principal, the interest, and then the seller will still have the pay for the utilities. Will
And
remain,
also the buyer's home insurance.
and the homeowner insurance, right?
If there's a HOA, you have to pay, and and the seller responsible for all the utilities and maintain the house.
Maintain the house,
the
right.
lawn and the pool and everything.
Yeah, and although it's one important thing to realize that's very, very important is that a UNO does not create a landlord-tenant relationship. That is that normally any UNO agreement will be written and reviewed by both lawyers for the buyer and the seller, and the parties will agree on the terms, but it will clearly specify in the UNO agreement that this does not constitute a landlord-tenant relationship. And that's a very important thing
that's debatable because, sometimes if they do themselves, they wouldn't know that. The lawyer always makes sure.
Sure, right.
Every UNO cross my desk, the lawyer always wrote.
They always have a paragraph that it does.
About that. But sometimes if they, we're talking to the audience here, they may buy and sell a house themselves. They may sell their neighbors, right? They may not have agent.
They may not have an
agent involved.
They may have a one-page UNO that just gives out how much you're going to pay me per day. You're going to carry insurance. You're going to pay the utilities. It might be very
but
simple.
You have to make sure for the buyer, right? If you give a seller UNO, it's not the lease. So you have to specify that to protect yourself. In case if the seller can't find property, for a while. So
Right. So let's talk about now the key terms, which we kind of touched upon. Obviously, one of the most important key terms is the duration, how long the UNO agreement is going to be for. Now, in your experience, it could be based on a per diem, and it could be 2 days, or it could be up to a month. Usually,
2 months.
You got to be careful though with certain lenders. Again, this is not certain lenders require the buyer to self-occupy within a certain period. So the UNO.
I think it's. Once again, we're not here to give you
legal
advice or mortgage advice, right? Generally, based on my own experience, a UNO max is 60 days. Yeah, because if you stay longer than that, the lender would have to charge the buyer investor's rate.
Right, because you need to. If you're getting a self-occupied loan, then the requirement the lender has is normally you have to, as a buyer, you have to occupy that property within 60 days.
Yes.
Or because some lenders it could be 30 days. Again, we're not 100% sure.
Right.
You have to talk to your mortgage consultant about that, but you just have to be aware of that and not violating that, because that could void your mortgage terms.
Absolutely.
Or qualify you as an investor as opposed to an owner occupied. So the duration is very important. That has to be spelled out in the UNO, and be aware of that, of the length period. And another thing is the occupancy fee, how much you're going to pay to occupy it. And it's technically not it's not rent, but it is in essence the same thing as rent. You're going to be paying.
It's not only. I disagree, Ken.
Well,
if it's rent, there has to be a profit in that, right?
Yeah,
Nobody want to rent a house.
That's true.
Lose money
right.
Unless
So it's
they
probably
have to.
It's a carrying cost.
It's a carrying cost.
It's a reimbursement to the buyer for their carrying costs.
Yeah.
Right. That's what.
But once again, that has to be specified in the agreement, because I did see earlier, a few years ago, there were 2 lawyers agreed on the UNO, but they didn't do the agreement yet. The lawyer was, a little bit too relaxed. So they did a deal, but in the contract said subject to the seller remain the house up to 60 days. And then the lawyer had to draw up the user occupancy. But they didn't draw up until up to the closing. Because we did the attorney review, we under contract, the home inspection.
Yeah, because normally the UNO, if it's agreed to in the contract, normally it's agreed to as part of the attorney review. That's normal, so they know. So the buyer.
Most lawyers don't do it. They do it at almost at a closing.
But then maybe some of the lawyers do it at the closing, because then they know realistically what the buyer's interest rate would be, so they can help accurately calculate the carrying cost.
But at least in the attorney review, you should have a one line. One line says, this agreement subject to UNO, the seller have right to remain in the property up to 60 days.
Oh, that has to
be they left one important sentence after that, at buyer cost rate. But they didn't say. They just say the seller have a right to remain in the property by UNO up to 60 days, right? And that was period. And then when we got UNO, they charge us extremely high number. And then we started argue, I mean, that's not fair. I mean, we only pay the cost because in that case, the buyer got a 10 years loan. Or 15 years loan.
Or it could be misinterpreted the other way. If you say that if you have in the contract that the seller is allowed to stay in the property post-closing for up to 60 days subject, as a use of the occupancy, you could interpret it that is for free too, because there's no cost specified. You could say, well, you didn't say we're going to pay you anything, so you could take it that way. And the buyer look at it the other way, say, hey, we didn't specify the costs, we didn't say carrying costs, so I'm going to charge you whatever I think I want to charge you.
In that case, at the end, it was like a really big issue because the buyer taking 15 years loan. So the monthly fee is huge.
The monthly interest,
monthly interest and not interest. Interest we not argue.
No,
the payment.
Right.
Because they said it cost me, my mortgage is $6,000. But that's because you had a 15-year loan.
Right.
If you have a 30-year loan, I mean, you may be much less. So at the end, the two lawyers have to argue a long time. Since then, I always, as an agent, I can't give any legal advice here, but I always make sure when the contract presented, I always make sure the buyer agent wrote in there. Right,
you could be proactive and write in there that the rate shall be based on a prevailing 30-year mortgage.
I would just say based on actually buyer cost, the cost because there's no profit. If you want to take a 15 years loan versus 30 years, that's your choice.
And then the seller would reimburse them for the buyer's cost.
Yeah, only the cost, which is the interest rate. We're not argue about the principal side.
No.
Yeah. And in that case, right, if it's a cash, and then the owner will be lucky. Because if the buyer purchase by cash, the cost to truly
would be the property property tax, and I guess the utilities are paid by the seller, so it would just be the property tax and the homeowner's insurance cost because once they
which
close
you have
title,
to pay anyway.
Well, yeah, but no, legally once you close title, then the buyer has that responsibility.
I'm just saying you will have to if you delay the closing. Right?
You would have to pay that anyway, just like the property tax. So really luck out then because you're talking much less without the mortgage.
No, sometimes it depends, right? I did a few deals back, in the 2015, 2016 kind of time, right? That's more regular time rather than COVID, the crazy bidding process. At that time, normally we work it out. If the buyer pay cash, they want to be compensated too. So what we did in a few cases is whatever the buyer's mortgage payment, how much cost the seller if we delay, say if we close in 2 weeks, 2 months later, for example, right? But we want to close earlier so we need the money to buy another house. So that's the purpose. So whatever cost us, we're happy to pay. So in that way, the buyer get a little bit of compensation. Because the buyer doesn't want to do UNO in that case. So we pretty much encourage them to do it to get a little bit of benefit. Instead of the bank can charge my client for the mortgage, we pay them.
So it's a win for both sides, right? The seller pays less than they would have had they closing been delayed, and then the buyer gets a little bit of compensation, so it's fair. So normally these things work out. There's
you have to discuss when the contract was presented. Yeah.
Right. That's important because if you wait till the end, near the end, then it's argumentative, and they argue about the rates and the terms and and mostly the compensation, the occupancy fee.
Yeah.
So that's a big thing. Yeah. All right, we're going to take a quick break, go to commercial. We'll be right back after these messages. Okay, welcome back to our show. So let's continue, Jane, reviewing the terms in a U&O. We're talking about the occupancy fee and how that has to be negotiated back and forth between the buyer and the seller, and how important it is for the attorneys to set the occupancy fee and as much of the U&O during the attorney review whenever possible. Because if you wait till close to the closing date and you don't have the U&O terms ironed out, it's going to make for a lot of disagreement and back and forth and just a lot of uncertainty as to getting it finalized. So earlier is better, and as you can, like we said, you can get iron out with as much specific information about the terms as possible. Mm-hmm. So the occupancy fee we covered. One thing about the occupancy fee that we should mention is that normally it's a little bit different. Normally the fee, from my understanding, the way they do it is whatever, if they expect that the U&O will last for 30 days, they'll withhold in escrow from the closing proceeds the expected occupancy fee and the next thing we're going to talk about, which is the security deposit. Normally, they get that, they hold that in escrow so that they don't have to. So in this case, where the seller's there, the buyer will have that money already allocated by the title company. So
always, because the thing is, Ken, if the seller have a user occupancy right, the final walkthrough cannot be done completely. Okay.
Right.
So that's why they have to have a security deposit. How do they know when the seller move out?
Well, no, I meant there's occupancy fee and then there's a security deposit.
So that's a security deposit. Yeah, they always ask.
There's always a security deposit.
Always.
Yeah.
Yeah, always.
Yeah.
Yeah.
And it might be equivalent to if they're going to stay a month, and then let's say the UNO it was $3,000. The security deposit might be like another.
I mean, for my experience, right? Most cases, right? The security deposit is about $5,000 to $10,000. It's most cases of $5,000 because as a listing agent, right, the seller attorney and myself try to argue to get as low the security deposit as possible. So far across my desk is pretty much $5,000. Is regular, but sometimes if the house is a really luxury home or is a lot involved, so they may raise it to 10. But so far, all the deals I'm involved is pretty friendly terms. So we know you can tell from the beginning, right? If everybody start to argue, you may delay the closing to do the closing rather than the user occupancy. So most of the cases are very friendly. So we just hold just in case because there are instance, right? After the seller move out, there were damage buyer wasn't aware of.
Right.
So
the intention for the security deposit is really just for damages caused by the seller post-closing of title, not for normal wear and tear. Just similar to a lease, where security deposit is truly intended for damage that was caused by the seller's, acts or negligence and something. So,
or something they couldn't see. For example, right, the one transaction I had was the seller had a king size bed. It's a big bed, and then underneath the bed, and then the rest of the from the entrance to the bedroom to the bed, they have a very nice, beautiful area rug. So you would think that you can see there's a hardwood floor underneath, right? But the home inspection, there's no way they can check the whole floor. So, but after we closed. And actually, there was a damage on the floor underneath the bed and also underneath the carpet. It happened, but once again, that was really
that's a good point,
that
right?
Wasn't
because when
really
a seller
deliberately, the owner literally forgot. It was a long time ago. They were just they put the carpet, the area carpet there is because for warmth. It wasn't really intentional, but that was unintentional. But when they moved out, and you can see. Actually, seller got a panic calling me, say, Jane, what do I do? What the buyer gonna say? What they gonna do to us? I said, just we voluntarily tell them we forgot. We just realized this problem, get a quote, and then we take care of it. That's it. So that was just a mistake. It was honestly,
it wasn't nothing that they did intentionally. It was just something that they forgot it was there.
20, 30 years.
That's true, because under a UNO from the seller's side, basically the furniture is still in place, everything is still there. So it's not so when the move out comes, the buyer is checking on everything and doing in essence doing their final walkthrough, which is we should say when the closing under a UNO, the buyer really doesn't do a final walkthrough. If there's going to be
they come
have a look, make sure the house is still standing. There's nothing. The AC is or the heating is still going.
Same like they were last time here to a home inspection.
Yeah, there's everything's status quo, but they really can't check every corner for hidden things that would only be visible once all the furniture the carpeting is removed, and area rugs and et cetera. So that's a very good point. That's something that you have to account for. That does come up from time to time. Another thing with the UNO that could be a little bit tricky is, let's say they close title. And if something stops working, let's say it's in the summer months and the seller is living there under the UNO for the next 30 days and the air conditioning system fails. So technically, the seller would in that case would notify their agent, and you would notify the buyer's attorney. that, hey, that's on that liability then transposes to the buyer to determine how to fix that, right? Because the seller no longer has ownership, so it's everything.
You know what, Ken? I mean,
luckily it doesn't happen too frequently.
But I normally recommend the seller. Say if the seller have UNO, if the HAVC is a little bit older, I always suggest the seller during the home inspection negotiation. The buyer always say this is working, but 25 years old, we don't know when they're going to break. I want you to service it. I want to certify it. I always tell seller, if you know you're going to have UNO for up to 60 days, may well offer buyer homeowner insurance.
Home warranty. Yeah.
So if you do that, and after that, you're there and a problem, and just call warranty company. You'll pay a service fee, and everything will be taken care of.
Yeah, that's a smooth way to do it.
So I always
you buy insurance for that
because you're gonna be there, and you don't want to argue with the buyer.
Because then the buyer might have the misperception that it's so unfair because you knew something, it just broke, it's unfair, and
that's why you want to
the seller would say, well, no, you had your home inspection, we negotiated, you got whatever you got from the home inspection settlement, and then that's just the luck of the draw. It just happened to go to fail.
I mean, a lot of time, right? Money is important, but peace of mind is more important.
Sure.
If you buy that a home warranty, it's like for the cost, it's worth peace of mind, especially you got to remain there for a month or two. You want to be comfortable just in case if anything happens. But obviously, if your HAVC is newer and this shouldn't be a problem, but it's just for the case by case. Sometimes I do recommend the seller to purchase home warranty just to be safe, have a peace of mind. Yeah.
Okay. Yeah, that's very true. One other provision that's very important in any UNO agreement are holdover penalties. And basically a holdover penalty is what it says is that if the seller does not vacate by the specified deadline in the UNO agreement, then there would be a penalty, and it would be a per day penalty, and they'd be on the steeper side, namely maybe $200 or $300 or $500 per day. And the idea is to make it steep enough so that there's an incentive for the seller to get the heck out, because otherwise if the penalty is too low, if it was like $50 or $100 additional, there'd be no incentive, and they could just say, well, I'll just gladly pay that because I need another week. But the buyer, it has to be steep enough so it's enforceable. And
they have to be much more expensive than living in Hilton, right?
Yeah, that's true, right. It's great. We should, I'm saying $200. You couldn't even get in a basic hotel. It should probably be like at least $500 based on the rates that the hotels are. Based on my recent travels, 300 to 500 is depending where you're staying
that's right,
or what you're staying in. Yeah, so that's very, very important to be in that. We should also talk about something we've been talking about UNO agreements from the seller's perspective. Yeah. They can be used on the flip side for the buyer to have a UNO agreement, which would be that the buyer. And it's very tricky when you're talking about it from the buyer having a UNO, but it would be the scenario where the buyer would move into the house before they close title on it. And that's very, very tricky because the buyer still hasn't purchased the property, yet they're living in there and they're paying a per diem. And I guess there are times when it's used, but it has to be a very well drafted agreement, and it's very risky because
it's
much more risky because if for some reason the buyer doesn't close on the house due to loss of employment, loss of mortgage, you basically have a buyer that's in your house, and it's problematic because how do you got to get them out of there, and they want the house, they love the house, but they can't buy it now, and so what have you seen? Have you experienced any?
I had one years back, right?
And wrap it up in about 2 minutes.
Yeah, very quick.
Good.
So years back, there was one. They had to move out because their buyer is not easygoing. Okay, they have to move out. So at that time, it wasn't easy to sell the house. So we work with them. So what I suggested that time, obviously lawyer tied up the agreement, is we had about I think 50,000 or 80,000 down payment, right? We make sure that's non-refundable. So, I mean, the buyer obviously didn't want to agree. I said, okay, you don't agree, you don't have a user agreement then. Because if you close on time, that's your down payment. If you don't close, that's non-refundable because we need that money to go to court to get you out, plus we can't show the house, plus potential damage, right?
Yeah.
So in that case, the buyer agreed. So the lawyer spent a lot of time draft that one to make sure protect the seller. As you said, Ken, if the buyer want to use occupancy before closing, it's much more risk than the seller.
And much more potential complications because the seller, the worst comes to worst, they
pay $500 a night. So,
right.
But for the buyer, is like, say, if especially the reason they want that use occupancy, maybe they back-to-back closing. If their closing didn't go well, that's going to triple for this one. So, as you said, the people can lose the job. Anything may happen. So it's a much more risk for the buyer to take a user occupancy.
Right.
Allow the seller.
All right, very good. So the bottom line is with any UNO, don't agree to it. Have it reviewed by your lawyer and make sure everything is gone through carefully. So you're aware of the terms, the deadlines, the dates, the fees, and a lot to it. We hope you guys enjoyed the show, and we'll see you guys next week. Enjoy the rest of your weekend.
Thank you.